up to about 40. We're up to about 45, 46 attendees. They're coming in rather quickly. I don't know if you want to wait another minute or two, if you want to go ahead and get started.
We can wait a minute, let everybody get in.
Sure.
It's just coming up on noon right now.
Hi, everyone. I'm going to say this again as we go along, but we do have a Q&A. If as we go along you have questions, it would be good if you could just pop them in there. This is a hot topic, Liz. Everywhere I go, people are amazed.
How are we doing? Do we have a good number of people are in here
68. Now? Yep, 68.
Right. Well, why don't we start and the others can join us? It's being recorded anyway, and they can see the beginning if they've missed it. And Anthony has a copy of the slides. If anybody wants those later on, they can ask MASC for them, and MASC can share them. So we ready to start, Liz?
We are ready, Liz.
Am I sharing? Because I can't see what you're seeing.
I'm not. Yes, you are sharing. I see your opening slide on update on public comment.
All right, so then we'll get started this afternoon. Nice to see you all virtually. We're going to talk about an update on public comment, and it has been changing, and it probably will continue to change. So stay tuned as things develop, but this is what it's like today. Can't promise you what it'll be like next September. We are going to, see if I can make my screen switch. Hold on a second, my slides seem to be frozen. There we go. I'm going to give you the usual disclaimer that this is for training purposes only. It is not legal advice. And if you need legal advice, you all should contact your own legal counsel for your school committee. We're going to talk about public comment during open meetings, which is what we've generally been talking about, but also some slides on public comment on school committee and district social media accounts, and also on your own personal social media accounts. So the open meeting law says that no person can address the meeting of a public body, which is a school committee or any of the school committee subcommittees, without permission of the chair of that committee or that subcommittee. And all persons at the request of the chair have to be silent. So if you are the chair, or you are running the subcommittee, or you are running a particular meeting and somebody is being disruptive, you need to tell them to be silent. And if after clear warning from the chair, a person continues to disrupt the proceedings, the chair can order the person to withdraw from the meeting, which means leave the meeting. And if the person does not withdraw, the chair can authorize a constable, which we never have any of those hanging around at our meetings usually, or a police officer to come and remove the person from the meeting. Now, we generally don't have police officers at our meetings, but if we have a hot topic and we think there might be disruptions, it's a good idea to ask your police chief to send somebody on over. The law does not require that every meeting or any meeting of a public body have a public comment period. It's up to the school committee as to whether or not it wants to have public comment, how long it wants to have it, and where in the agenda it wants to put it. And this is, but if you don't have public comment, you should have another forum by which the public can communicate to you. And that might be by email, could be correspondence through letters, but that would be another option. The law does not describe what a disruption is, although we all know it when we see it. Obvious examples would be when somebody forcefully grabs the microphone from another speaker, or when you've recognized a speaker and then you tell them their time is up and they just keep on talking. So those are the kinds of things that are disruptions. And it doesn't only occur during the open meeting part, it can occur at any time. So remember what I said to you about the other slide that just simply said you have to give them a warning to be silent. And if they don't, then you can have them removed. It's not, they don't get 3 strikes. They get one warning, and then the next time they're removed. But make sure the warning is clear. The Barron case is a SJC case in Massachusetts And it had to do with the Southborough Select Board policy. And wouldn't be no different if it was a school committee policy. They had a public comment policy that said all remarks and dialogue in public meetings have to be respectful, courteous, free of rude, personal, or slanderous remarks, and inappropriate language or shouting will not be tolerated, and that they cannot offer comments without permission of the chair. That is in the law. The chair has to recognize any speaker. And at the request of the chair, they have to be silent and nobody can disrupt. Well, that part is part of the law, but the rest of it isn't. So during a public comment portion of the meeting, a commenter began accusing the select board, of breaking the law, and the chair objected and called it slander and indicated he was going to end the public comment portion of the meeting. The speaker then just said, "You need to stop being a Hitler. You're a Hitler. I can say anything I want." Chair ended the session and the commenter brought a lawsuit. And the lawsuit went up, and it was under the state's MASC Declaration of Rights, but it's very similar to the First Amendment free speech under the US Constitution. Superior Court judge ruled on it, but then the commenter appealed. Commenter goes up to the appeals court, and the Supreme Judicial Court, the highest court in Massachusetts state court, took it. Well, the SJC looked at the issue, and it ruled in March of 2023, found that the board's policy violated the state's Declaration of Rights, specifically the board's policy that all remarks and dialogue in public meetings have to be respectful and courteous and free of rude, personal, or slanderous remarks. And inappropriate language and or shouting will not be tolerated. They found that discourteous, rude, and disrespectful or personal speech about government officials and government action is protected by Article 16 of our state constitution, our Declaration of Rights, and therefore the prohibition is impermissible. They did a strict scrutiny standard. They looked at this policy because it targeted political speech. Barron case said that certain types of restrictions would be okay. They would not violate us. Reasonable time, place, and manner restrictions. So how much time you let somebody speak. That so long as the time limits for each person during the public comment session is the same. It's not about, if I like what you're saying, you get more minutes. If I don't like what you're saying, I cut you off with fewer minutes. Or I let you extend the time if I like what you're saying, but I don't let you extend the time if I don't like what you're saying. You can't do that. It also observed that in order to function efficiently, towns, and it would be the same for school committees, must be able to hold public meetings limited to a particular subject. So if I want to talk about, and I will give an example, when I was on my school committee, we talked about whether switching the first bus run and the second bus run, there was standing room only. But we actually did a special meeting because we knew that the public comment part of that was going to be so engaged. But at that meeting, we wouldn't have public comment about the school budget or about curriculum. We limited it just to that. And that's okay to do, especially if you have a hot topic that lots of parents are interested in, public members are interested in commenting about. The court did not address whether you could have a policy that said you could bar speakers from engaging in slander.
Liz, we have a couple questions here that are relevant to what you just talked about. One, it would be whether a school committee can decline to hear public comment from people with no connection to the district. And if you cannot, can you prioritize comments from people with such a connection to the district?
So the Barron case didn't address that, but in some of the slides coming up, I'm going to talk about that because I think there have been people traveling from the Midwest, for example, about books in our libraries. I mean, they don't care what the families in Arkansas think about the books in our libraries. I care about what the people in our community care about the books in our libraries. And so we wouldn't want to spend time listening to them, but it can't be that we only do it once in a while. Like, it has to be a known policy. You have to publish it. And then we'd say that we are accepting comments from residents of the community. I wouldn't call it citizens because we're not going to check anybody's citizen status. Residents of the community, employees of the community, children, students who come to our district schools, and their parents or guardians. Because remember, some of us have METCO, some of us have school choice. So we may have parents and we may have students who don't reside in our community, but who are part of our school community. So I wouldn't just say residents, but we could limit it to some of those folks and not all of the people from the planet, because we don't really care about what people in Arkansas think about our books. And I only use that because there have been some issues of people sort of traveling around complaining about books in kids' libraries. Okay.
Couple of important ones, and this is directly to timing. If someone from the public is attending virtually, can they be muted when their allotted time is up?
You have to stop their time just like you stop everybody else's time. So it isn't any different if they're communicating that way or they're communicating by standing in front of the microphone that you set up in a physical location. When it's time, they have to stop. And
Thank you. And
oftentimes we give people, a 15-second or 30-second warning.
I imagine you'll get to some conversation about whether staff members can be spoken about directly by name in a derogatory manner. So we'll hang on to those until you get
Well,
there.
we make sure if I don't address it, make sure you remind me, Liz.
Thank you.
Okay, so we talked about this slide. Takeaways from the Barron decision. A speaker cannot be barred from engaging in disrespectful, rude, or personal speech directed at public officials. You can't say you have to be nice to me, or you can only say nice things about me. And frankly, they can say just about anything they want. And sometimes it's pretty awful. We have to remind them that oftentimes we are volunteers doing this for our community. If you don't like what I'm doing, vote differently next time I'm up for re-election. The committee cannot treat speakers differently from each other based on their views or how those views are expressed. So if somebody comes in to say things about how great the new curriculum is, you can't treat them by giving them extra time to talk about it. And then the person who wants to tell you that your new social studies curriculum is terrible, you can't cut them off. It can't be content-based. The committee can impose reasonable time limits for the entire public comment portion. So the court didn't address what that would be, but 10, 15 minutes should be enough. You are elected to use your judgment, and you don't need to poll the public. And oftentimes the loud voices who show up are not necessarily the majority of the people and their views. So I think you have to decide how long you want to devote to public comment if you're going to have it. And then you need to stick to it. I found when I was chair of my committee that it was always helpful to remind the public about how much time there is and what the rules are, so that someone who's coming for the first time isn't surprised when they're cut off at 3 minutes, if that's what you give them. The committee can impose reasonable time limits for each speaker, and that was I used 3 minutes as being reasonable. You can get a lot out in 3 minutes. Speakers can be barred from engaging in dialogue with the committee. And this is actually important, and I have another slide on this, because if you start going back and forth, you may actually start deliberating about a matter that's not on your open meeting agenda. So if there's something the committee wants to deliberate about that was raised by the public comment, you can add it to your agenda for a future meeting and it'll be properly posted. Speakers can be barred from interrupting or interfering with other speakers. They can be barred from engaging in physical conduct. They can be barred from engaging in speech that threatens violence or incites an imminent unlawful conduct by others. That doesn't mean they can be barred from using really bad words. You can try it, but I don't know that it'll work. The committee should be able to limit a public comment session to specified topics, such as matters that are within the body's jurisdiction. So if the school committee does not want to hear public comment on whether or not potholes should be filled on somebody's street, that goes to the select board, not to you. But it does want to hear comments about things that are curriculum that you might be changing, start and end times of the school day, all those kinds of things, or matters that are on the posted agenda. Maybe you just want to limit what people talk about to things that are on the agenda that you're going to address that evening. You may be able to limit participation to residents, individuals attending the district schools and their parents or guardians, and individuals working in the district schools. The SJC did not address this, but I do think that you don't have to listen to the whole world. You have important things that you have to get to, and you don't want to be derailed by people who are not part of your community. The committee may request that participants sign up in advance so that the public comment session you can take people in order and it can be done in an orderly, efficient manner. You cannot ask them, however, to sign up and tell us what you want to talk about and what your opinion is. So we did not address, the SJC did not address some other parts of the issue. So for example, the part about whether you can, the policy in the case talked about the use of profanity. They did not address that. But it certainly didn't say whether or not you had to have an open session, in your open session, whether you had to have public comment. So you have to decide whether or not you want to have public comment. If you do, then you need to put some restrictions and some policies in place that you uniformly apply. You cannot be lenient. And that includes when the cutest little second graders come up to tell you something and it's taking 3.5 minutes, they have to be held to the same 3 minutes. The other thing is some committees have policies, some municipalities have local charters or bylaws that say that you must have a public comment period. If that's the case, you need to check yours to be sure if you decide not to have one, that you aren't violating any of your public comment requirements in your town charter or in any bylaws. I told you that the SJC didn't talk about profanity. It also didn't talk about slander. Slander is the act of making a false spoken statement damaging a person's reputation. Well, we see a lot of that in politics. And statements about public officials, even if they're false, and you are all public officials, statements about public officials, even if they are false, generally have to be made with actual malice. That's with the knowledge that it's false or reckless disregard for its falsity to be considered slander. And otherwise, those of us who have served as public officials have to be able to shoulder a great deal of criticism and statements about us, even those that are not truthful. That doesn't mean you can't correct them elsewhere, but it does mean that you can't stop them from saying it in the middle of the public comment meeting. And as I said before, they didn't address the issue about profane language. Now, there's nothing that prohibits you from asking people to not use profanity. Especially, often we have a student representative to the school committee and there are children present. We would prefer that they not use profanity. You can certainly request it. You can't require it and you can't shut them down for using it. So remember, the committee cannot apply its rules based on the content or viewpoint of the comments. The rules have to be applied uniformly without regard to the content. All rules are permitted under the Barron decision. For example, if the committee bars dialogue during the public comment session between the committee and speakers, that has to be applied to all speakers.
May I ask a quick one here, Liz, that might
Sure.
apply directly? Is there what if some folks want to give their 3 minutes to another person, which would effectively give that person 6, 9, 12 minutes to speak?
Oh, I love that. I'm going to turn over my time and we're going to have 10 people turn over their time. The answer to that is no, unless you have a policy or a practice allowing them to do that. I would not do that. Each speaker gets a certain amount of time. Now, they could print it all out and somebody could start and read the first 3 minutes and then hand the paper to the next person who reads the next 3 minutes and go on like that if they want to. But they can't basically change your rules by letting somebody else have 30 minutes. If the rule is 3 minutes a speaker, it's 3 minutes a speaker. And you don't get to give your time to somebody else. And if you want to make that clear in your policy, that would probably be a good idea. I have a draft policy in some of these slides. I'm not going to read it to you, but you are certainly welcome to get the slides from Anthony or Liz, and then you can add that to the 3 minutes per speaker, and speakers cannot tack on time from other speakers. And again, to remember to avoid a violation of the open meeting law, consider barring dialogue during the public comment session between the committee and speakers so that the committee does not inadvertently engage in a dialogue or a deliberation about a matter that you didn't list on your agenda. So some do's of managing public comment: have a clear written policy setting the time, place, and manner restrictions. Set time limits for individual speakers, and that's where you would add, and speakers can't give their time to someone else. Only one speaker at a time. May require speakers to sign up in advance, limit comments to subject within the committee's jurisdiction or items on the agenda, place regional restrictions on who can speak. That's what we talked about: residents, families with children in the district, students in the district, employees in the district, that sort of thing. Place limits on the speech only to the extent necessary to hold an orderly meeting. So you can prohibit remarks about subjects that do not fall within the committee's jurisdiction, advertising, for example. And You can prohibit obvious acts of disruption, grabbing the microphone, speaking when you're not being recognized by the chair. Some don'ts. Don't limit any speaker based on the content or viewpoint of their speech. Now, the case that I told you about, the Barron case, that had to be defended. So, and it went up to, from the lower court to the SJC. Litigation costs you money. You don't need to do this. Like a mistake that costs you money later on isn't worth it. Just don't limit their viewpoint. And if the public hears something about their viewpoint they don't like, then they'll see it. Focus should be on disruption. So some topics can be more subject to controversy than others, such as changes in curriculum, start of the school year, bus routes, library books. But just because it's controversial doesn't mean it's disruptive. People are going to have emotional reactions sometimes, and we just need to let them have their 3 minutes or 2 minutes of whatever you decide. Do not apply the rules inconsistently based on what the speakers are saying. And if one speaker engages in conduct that causes the chair to issue a warning, throws something at the committee, that person has to be removed. Then that happens again by another speaker, that person gets removed. And as I said before, unlike baseball, we don't give them 3 strikes. You get 2. 1 warning, next time you're out. So we have a couple of examples. The meetings that go on too long. Best school committee meetings usually start at 7 and have been lasting until after midnight because the public comment portion of the meeting, which has been placed as one of the first items on the agenda, has been hours long at each session. This has resulted in the committee not starting its business until 10 p.m. or later. Committee members are tired by the time they get to the committee's business, and often much of the business requiring deliberations and votes is delayed to future meetings because members need to leave before the business is completed, resulting in the quorum being lost. What are some of the options the school committee can take to address this? The committee can limit the amount of time on the agenda for the public comment, limit the amount of time each speaker gets, adopt a policy that restricts comments to items within the committee's jurisdiction or on the posted agenda, restrict participants to individuals who reside in the municipality or work for the district and whose children attend the schools, or schedule a separate meeting for public comment on a matter where there's a lot of interest in public comment. Lawrence Loud, this is another example. Best School Committee has a policy that permits members of the public to speak for 3 minutes during the portion of the committee's open meeting set aside for public comment. Individuals wishing to be recognized sign up to speak. The chair has always called them in order on the list. On September 5th, Chair Empire got to the public comment portion of the agenda and called the first 3 speakers in order. The chair inadvertently skipped the 4th speaker and recognized the 5th speaker. As the 5th speaker began to make his comments, the 4th speaker, Lawrence Loud, interrupted him and demanded to be heard next. What should the chair do? If we were in person, we'd actually do this, but I can't see you all, so I'm just going to go give you a moment to think about that, and then we're going to go through the answers. Remind the public that only one person has the floor and that the permission to speak at any given time, and the chair may issue a warning and request that Lawrence Loud be silent while the 5th speaker begins to make the comments. He's already recognized the 4th speaker. After the chair directed Mr. Loud to be silent, Mr. Loud went to the microphone and grabbed it from the speaker whom the chair had recognized. Now the chair, that's a disruption. The chair can absolutely, he's told him to be silent, to sit down when the 5th speaker was speaking, wasn't recognized, even though he inadvertently skipped him. And then he says, okay, he takes the microphone, he's out. You've got to have him removed. So we can order to leave, and if he doesn't leave, we can have him removed. But what if Chair Empire didn't inadvertently skip Mr. Loud, but did so intentionally and at multiple meetings because Mr. Loud had been critical in the local newspaper and on social media about the committee's school redistricting plan? Now I've got a violation because he's not doing it based on just an inadvertent skip. He's doing it deliberately because he doesn't like what Mr. Loud is going to say. Now we have an issue. So remember that the committee cannot apply its rules based on content or viewpoint of the comments or the commenter. Fran Fire, during the public comment at the Best School Committee meeting on August 14th, Fran Fire was recognized to speak by the chair. Fran started off by saying the following: "You don't know what you're doing. You're failing our kids and you don't care. It's as if our schools are on fire and you are taking your time calling the fire department. I pay taxes here, so you all work for me. You should all be impeached, but until then, I know where each of you lives, and don't be surprised if you wake up one morning and find your house on fire. You all better watch your backs when you leave tonight." Fran was about to continue speaking, as her 3 minutes were not yet up, when Chair Empire took action. What did the chair do? Issued a warning that threats of violence are not permissible and that further threats will result in the chair asking the speaker to withdraw from the meeting. Remember, true threats are not protected by the First Amendment, and words that literally threaten but have an expressive purpose. So if you are threatening a true threat, and I think if we go back to here, "You all better watch your backs when you leave tonight," that's a true threat. That's when you actually pause your meeting and call your police officer. All right. Confidential student information. This comes up a lot. Penny Parent has a 9-year-old daughter with an IEP in the district's elementary school. She has been very unhappy with the district's director of student services and with the IEP process. And for those of you, that's the process where a special education plan for our students who have special needs. And she didn't agree to provide an outside placement for her daughter. The Good Public School Committee has no policy on public comment, and its meetings on August and at its meeting on August 14th, Penny Parent was recognized by the chair to speak during public comment. Ms. Parent asked the committee to set up a task force to report to the Committee on Special Education in the district. That's certainly within this committee's jurisdiction. She explained that she had personal knowledge that the current system wasn't working. She then identified her daughter Susie by name, listed all of her disabilities, described in detail episodes of Susie's repeated dysregulation at home and in school, read her IEP, and recited her grades from her report card to the committee. Most of that, almost all of it, except maybe her name, is confidential information protected by state and federal laws. She then pleaded with the committee to review how the district is addressing the needs of students with disabilities, and again asked the committee to set up a task force to report the Committee on Special Education in the district. Could the chair have stopped Mr. Parent, Penny Parent, from disclosing confidential student information about Parent's daughter? No. Nope. And they weren't asking, there was no threats. The parent wants to disclose their own child's information, they can do so. This may go to the question about can somebody come and talk about an employee? They can, and the employees don't like it and the union doesn't like it, but we actually don't have a right to stop that. Now, if they slander the employee can file a civil action against the commenter, the public member of the public who slandered the employee, but we can't.
May I ask a quick question here, Liz?
Sure.
Because I did answer this for someone. However, understanding that you cannot stop them from having their time to speak, could the chair stop the timer, for example, and say, "I want you to just be aware that, this affects your students' right to privacy. If you wish to continue, you do so with that understanding"?
You could do that. I think I would do it at the beginning of every public comment session. Say, "This is the time it's allotted. We want to remind you, our meetings are being recorded, and that while you have the rights to make, statements, just remember that this may, if you talk about your children's confidential information, that's going to be out there." And sometimes people don't realize that. There was a speaker once who talked about, and it was really quite sad. It was a speaker who talked about the undocumented status of the speaker's family, that put that family and that speaker and those students at risk. So, sometimes people don't realize what they're doing, but it's not our job to protect them. So yeah, I mean, could you stop it? I don't think I would have. I let them go on and just go, because you wouldn't stop anybody else unless it's a threat or a disruption.
And here's a follow-up from one of the participants. Can you cut off a speaker who is revealing information about another person's child?
No, because they didn't get that. Well, now, if assuming the speaker is not one of our employees who got the information from the work with the child because they're an employee, But if this is just, like my neighbor, my friend, my grandchild, no. But that parent may have an action against them, but they got that information somehow. So it was not necessarily, they may have shared it. Once you share your information about your kids with somebody else, it's not necessarily going to stay private. Dan Disruptor, Best Public School Committee started its open session meeting at the posted time at 6 p.m. The first item on the agenda after approval of minutes was public comment, which by policy is not to exceed 15 minutes. Not to exceed 15 minutes. Public comment started at 6:20, but there were only 2 persons who were present to speak. When they completed their statements and no one else asked to speak, Chair Empire ended the public comment section and moved to the next item on the agenda at 6:26. Dan Disruptor arrived at the meeting at 6:30 and noticed that the committee was on the next agenda item after public comment. He shouted at the chair saying, "Hey, public comment isn't over. I want to speak now. You have to let me speak. I have a right to be heard." What should the chair do? Direct Dan Disruptor that he has not been recognized by the chair and therefore does not have the floor to speak. Dan Disruptor does not have a right to speak. If Disruptor continues to be disruptive, the chair should call for a recess, provide time for Disruptor to come down and then resume the meeting, or start with the next item on the agenda, or have him removed by the police. Just because an item is listed, and you might make sure that sometimes we put these things on the agenda at certain times, not to exceed 15 minutes is what you might put there. So if it started at 6 o'clock and it's over with, he missed it, too bad. BAT demonstration, Best School Committee and the Best Association of Teachers, that's the union, the acronym is BAT, have been engaged in negotiations for a new contract. BAT wants more money than the committee has offered. BAT directed its members to storm the committee meeting with their signs and chant, "Fair contract now." At the Best Committee meeting on Thursday, 200 BAT members carrying large signs marched into the meeting that was already underway, interrupted the superintendent's report, and chanted, "Fair contract now." What can the chair do? Give a clear warning to cease the disruption, and if the disruption continues, then they either have to call for a recess, have the individuals withdraw from the meeting, adjourn the meeting, call the police if you need to, but frankly, that always looks bad. So you might just adjourn the meeting or have a recess until they came to do the demonstration. Cable TV saw it. It was live on Zoom and live on Facebook or wherever they posted it. Then it was over with. Paul's Pizzeria. Paul has been working for years.
Liz, I'm
Yep.
sorry,
Don't apologize. Interrupt whenever you have
related to
questions.
negotiations directly. Can we limit public comment from those who are from a different community speaking on our district's negotiations?
It depends. If your policy is that you have to be an employee, a resident, or a student, or a parent of a student, or then the answer is yes. If they're none of those people. However, if they are somebody that, if they are a representative of your union, I would say they represent your employees. So if they're like an MTA rep, they're a representative of your employees. You can't say, no, you can't speak to us, because that would be a violation of the state labor law. If you're allowing employees can have their representatives speak for them. Does that answer the question that was asked?
I think so, Liz.
Yeah. But again, if you only have 15 minutes, and there is nothing wrong. Sometimes we're getting an awful lot of people signing up for our public comment, and there is nothing that prohibits us from reminding some of our neighbors who say, "You know what, I love that new field you did for soccer," coming in to say, "Hey, thanks for the new soccer field," and someone else for saying, "The second grade concert was just great. And I love that art exhibit we did." Like, it's okay to invite people to come and make those comments so that it's not always the negative comments, especially when there's a lot of stress going on in the community because of negotiations. Paul has been working for years on his recipe for the perfect pizza and opened his own pizza shop down the street from Best High School. He is excited to let the community know about the menu and pricing, but after paying rent, leasing pizza ovens, and paying for employees, he has no budget for marketing. At the Best School Committee meeting on Thursday evening, Paul signs up for public comment. When Chair Empire recognizes him to speak, Paul introduces himself and then starts reading from his menu, including the descriptions of his amazing pizzas and the prices. Paul has practiced so that he can get through the menu in just under 3 minutes. The committee has a public comment policy that limits comments to matters within the committee's jurisdiction. What should Chair Empire do? He should cut him off. We don't do advertising. So direct Paul comments are to be limited to matters within the committee's jurisdiction. If Paul continues, the chair may bar Paul from continuing to speak. I told you there was going to be a draft policy. Here is the draft policy. It covers several slides. I'm not going to read it to you, but I do want to point something else out to you. In this draft policy, there's this part that I've highlighted. It says use of profanity or obscenities. The court did not address whether people can be prohibited from using profanities or obscenities. So you may not want to include this in the policy, but I put it in the draft for your consideration. There is no court decision on whether you can prohibit them from doing that. Some additional notes. Committees are not required to have a public comment session at each meeting, and that includes subcommittee meetings. In fact, many of our subcommittee meetings, except maybe policy and budget, don't usually have a public comment section. Consider the length of the public comment so that, and where you place it on the agenda. If you want people to hear about a particular agenda item and it's important for the community to know about it, then put the public comment section afterwards so that they sit and listen to that part and then do the public comment. If you put it first, you'll notice that oftentimes, especially if you're in person, the audience just sort of is reduced after they have said what they came to say. Anticipate disruptions and be prepared, especially if you're talking about a number of hot topics. Always apply restrictions on public comment uniformly and without regard to viewpoint, and review and revise your policy so that it is compliant with the SJC Barron decision. Any other questions before we move on to public comments on district social media? Okay.
Liz, I think we've done pretty good so far. There's been a lot of repeat questions, so thank you.
Okay, I'll keep going. All right. This is something we've added to the presentation on public comment, which is most of our districts have a lot of social media. They have Facebook pages and Instagram and other things. So one of the things we want to be careful about is when you're posting district announcements and information about, it's great for posting announcements. Parents know where to go. Sharing resources and links for students and families, connecting with the community, keeping our operations transparent, posting photos of events. Of course, those are all for people with kids who haven't opted out of the photos, and receiving feedback. The receiving feedback, though, that's the part that gets us in trouble. So it's great to push out stuff. It's when you get stuff pushed into your social media that we have to be careful. So public forums, we have open public forum. That's, the parks and the sidewalks and lots of places in front of the post office, by the recycling center, and so wherever people are meeting and talking. That's a traditional public forum. And then we have designated public forums, are spaces which have not traditionally been regarded as a public forum, but the government has intentionally opened them up for that. And then the standard for reviewing whether something in a public forum can be taken down, blocked, hidden, removed, is reasonable time, place, and manner restrictions on speech. So we can put reasonable time, place, and manner restrictions. A limited public forum is where the government's created a forum that's limited to use by certain groups or dedicated to certain topics. And that restriction can be based on subject matter if they are viewpoint neutral and reasonable in light of the purpose to be served. So let's talk about that. The First Amendment says we have to always think about First Amendment and speech rights. So social media websites and applications provide the public with the opportunity to make their own posts or comments on others. This creates a First Amendment issue, because if I push things out and I have no place for people to comment back, no First Amendment issue. I'm just giving you information. It's kind of like if I have a sign out in front of the school and I tell you what time school starts. I push this information out, but there's no way to post something back. But if you don't put a limitation on the use that people can post back, then you've got the issue of creating an open forum, and then you have to watch out for First Amendment. So some municipalities in school districts are permitting comments, but designated as a limited public forum. So it's limited to certain things. So to establish a limited public forum, and you've got to make sure your terms of use in this social media are clear and explicit. And you're going to check this because oftentimes we haven't updated it. In order to, you have to reserve the right to remove comments and that are off topic. Now, off topic has to be defined rather in a reasonable way and kind of narrowly. So not off topic meaning I don't like what you said and it's negative, but off topic is this is about our school and we don't care what your pizza menu is down the street, right? Because that's not about what we're doing. That includes, we can also say that we can remove comments that include obscenity, fighting words, true threats, commercial promotions, Paul's Pizza, or advertisements that are harassing or discriminatory on the basis of any protected class and that encourage illegal activity. So there was a recent case that just came out this summer. It's People for the Ethical Treatment of Animals. You know them by the name PETA. And PETA has been for years watching what the National Institute of Health does. Now, the National Institute of Health, the NIH, has a social media page promoting it. It talks about what NIH does, and it prohibits off-topic comments. Well, the court found that their off-topic comments was unconstitutional because they had put some filters on. Let me go to the next slide. So comments to the social media pages were governed by this guideline of off-topic, and to enforce it, they put these default filters on the platform that looked for keywords. And the keyword filters were PETA, and then PETA Latino, animals, mouse, chimpanzees, cruel, and cruelty. Now, NIH does support lots of research that is done on animals, and PETA is one of the animal rights groups. So PETA is a group, it's not necessarily an off-topic. So in light of NIH comment guidelines, the comment threads were held to be limited public forum. The court ruled that the use of the keyword filters, remember all of these filters here, PETA, PETA Latino, animals, mouse, chimpanzee, cruel, and cruelty, they were not reasonable in light of the purpose of the forum to communicate and interact with citizens. And the court reasoned that the NIH failed to articulate a standard for distinguishing off-topic from on-topic, because PETA had plenty of on-topic posts. They just didn't like them. NIH didn't like them, and they were immediately, because they said for PETA, they were taken off. So further, the court noted that the word filters were unreasonable because they were inflexible and did not account for the context in which the comments were made. So takeaways from the PETA case that we can apply to what we're doing is if you have a prohibition against off-topic comments, it has to be enforced pursuant to a workable standard that ensures it is viewpoint neutral. So if PETA was saying, hey, we think your research on animals is great, it would have come out, or because it was PETA, it didn't matter, it was who was saying it. Flexible to consider the context in which the comments are made. So you have to worry about filters that have categorical bans on certain topics. When using keyword filters, you have to review the terms that are being used. So I think this is something that the committee has to look at as to how, if it is filtering out comments, if it doesn't filter out anything, then you don't have to worry about it. But then you are going to have off topic and on topic.
Liz,
Yeah.
there's a question about whether you can turn comments off on social media posts. Now, I wonder if this relates directly to school district posts or school committee member posts.
So if you want to be, the safest way to do it and have no litigation is to not have any comments. You can't turn somebody's comments off. You can't just turn PETA's off, but the University of I'm testing and getting money from NIH's comments on, right? You can't do it by that, but if nobody can comment, that's okay. That's a push out system where I just push out information, and you want to send me a comment, you send it to me by an email somewhere, or you send it to me by a letter, but I'm not putting it on my social media. So you can do that. What you can't do is do it by viewpoint or by the speaker. So if your district has a social media account, want to consult your legal counsel before deleting any user's post or comments from the account. You could have a violation of the First Amendment if only off-topic posts are removed when they are negative. So if the ones that are positive about you are kept on, even if they're off-topic, that doesn't work. Posts are removed based on their content instead of the explicit narrow grounds for them being removed. And posts are removed because of viewpoint. And you have to do it consistently, which means somebody's got to watch it all the time, which is why it's easier to not have comments back and instead let people communicate in a different form. Send you an email, send the district an email, send them a letter, if anyone still uses letters. Now, First Amendment and committee members' social media accounts. You do want to review the terms and use of the platforms or the hosts that you have. If you are going to respond, be cautious if you're responding individually, and if you're going to block others from your own social media accounts. Because, so as a public official, you have a private life and you have a public official life. And sometimes those lines get blurred and it makes it really difficult. So let's look at a couple examples and I'm going to talk about that some more. Best Public Schools District contains a Facebook page for the purpose of communicating district updates to students, parents, and members of the school community. In addition to Facebook's terms of use, Best Public Schools also maintains a publicly available guideline that prohibits off-topic comments, obscenity, advertising, harassment, and threats. In February, Best Public School District posted an alert to the Facebook page that school will be closed due to snowstorm. Local businesswoman Profiteer Patty comments on district's post advertising that her restaurant will still be open for delivery at discounted prices. Can the district hide Patty's post? Yes, because it's an advertisement. It's not off this. If she was saying something about how a snowstorm wasn't going to be that bad, fine, that can't come off. But this is actually an advertisement. It can be taken down. Only because you also had a policy and you disclosed it. There was terms of use that said you can't advertise on us. You can't use our forum to advertise. I want to remind you that when you all communicate on social media, you may be violating the open meeting law, because if a quorum of you start communicating on a topic, and communication can be just a thumbs up emoji, that's a communication, or a thumbs down one, or a funny face. Once you start communicating, and you have a quorum, you may, on a matter that is within the jurisdiction of the school committee, you will have an open meeting law. So under the open meeting law, postings and comments on social media can be deliberations, even if it's through your private social media. Public records law also requires us to maintain copies of all this. So communications made on social media accounts need to be archived. So the district needs to have a system to retain all of this information appearing on the district's social media accounts if the information could be viewed as a public record. And any electronic communications created or received by a public employee or official in his or her capacity as a school committee member, for example, is subject to retention and possible disclosure under the open meeting law and under the retention law, even if it's on your private social media or your own text messages from your own phone. So your personal communications on a school committee issued computer or laptop are subject to public records and requests and subpoenas. Content on your personal accounts, computers, phones, and other devices can become subject to public records law if it's found that your communications were part of your official functions as a school committee member. Linking your personal accounts to your school committee accounts increases these risks. Keep things separate. Email about school committee things using school committee topics on your school email account, personal stuff on your personal email account. If you link your school committee accounts to your personal accounts, ensure that you have a method and a manner of retaining the content, because it could be considered official work and public records. So blocking constituents on private accounts. Government officials, such as school committee members, should proceed with real big caution, and you should contact your counsel to help you on this when blocking a constituent on a personal social media account. In March, the United States U.S. Supreme Court issued a decision in Linke versus Freed, in which it set forth a two-part test to determine whether a government official is acting in their official capacity when engaging in social media, and it was about his own social media account. So that one's out of order. Let's go here. Oops, hold on a second. There we go. In Linke, the city manager, James Freed, had his Facebook page public. He primarily posted about his personal life, but he also posted information related to his job, such as soliciting feedback from the public on issues of public concern. When Freed posted about COVID-19, a constituent commented on his post expressing displeasure with the city's approach to the pandemic. Freed blocked the constituent and deleted his comments because it was his personal account. He thought, I can do that. The constituent sued Freed under Section 1983, alleging that Freed violated his First Amendment rights. And in Linke, the Supreme Court examined the private parties can act with the authority of the state, and state officials have private lives of their own. So if there's a test that they're going to put through, first, the official has to have actual authority to speak on the state's behalf on a particular matter, or a school committee chair or member might have actual authority to speak on the school committee's behalf. Second, the social media activity to constitute state action must not only have state authority, but must also purport to use it when making the relevant post. Oh, member of the school committee or chair on personal social media says, I wonder what my constituents' views are on whether we should start before Labor Day, students before Labor Day or after Labor Day. That's within your relevant authority. So the court remanded the case for more factual record, and that hasn't come back yet. But when it does, it'll be important to read. But one of the things I wanted to point out is Freed did this is on his own personal account, his own social media, not on the municipalities. And it still went up to the US Supreme Court. So take away from that, you want a disclaimer. This is my personal page. The views expressed on this page are strictly my own. It would also be nice if you if you put your Facebook page or whatever you're using to private so that people cannot comment back. And because that will at least keep you from basically to your friends and family and not to constituents. Ross Geller is a member of the Best School Committee. Ross maintains a personal Facebook and Twitter account, which he occasionally uses to communicate about school district business and news and inviting constituents to provide feedback. Julie and Charlie are parents of school district students. They believe that their concerns over race relations in the school district are going unheard despite their regular attendance at school committee meetings. Julie and Charlie decide to turn to social media and begin posting hundreds of repetitive comments on Ross's Facebook and Twitter pages, voicing their concerns. Ross blocks Julie and Charlie from his personal Facebook and Twitter accounts. What are the issues with Ross blocking Charlie and Julie from these accounts? Ross posts on his personal accounts have blurred personal use and official school committee business, thereby implicating his First Amendment issues for the two people who are posting that he wants to block. He has mixed a personal account with matters that fall within his role as a member of the school committee. So this is an example that's similar to something that happened in the Ninth Circuit. And I think we've got to be incredibly careful not to blur those two things, because you can be found to have violated someone's First Amendment rights by blocking them, taking down their posts, even on your own personal page, which I think is something that we haven't been seeing in the past, but we are now seeing that more. So best practice, avoid mixing your personal with your official posts on your personal accounts. And I left about 5 minutes for us to do some hypotheticals or some questions. Liz, do we have any questions?
Well, Liz, thankfully, I've gained so much good information from attending your sessions. I answered quite a few that you did not answer. So if anyone has questions that still remain to be answered, now's your chance.
And I can stop sharing, which might help so people can see. No more questions? I feel like I galloped through quite a bit of this, but I wanted to make sure we could cover the part on the district social media and people's personal social media, because public comment there is becoming more popular.
It is, and troublesome. Here's one. Does commenting on social media by a school committee member regarding school business create an open meeting law violation because it hasn't been posted ahead of time?
If you have a quorum of the school committee members reading it and commenting on it, yeah.
Okay. What about a school committee member representing their personal opinions?
You need to make sure it's very clear it's your personal opinion. But if you're talking about official school committee business, if you have a 5-member committee and 3 of them decide to talk about their personal opinions on the school committee business, you have a open meeting law deliberation violation. You have violated the open meeting law.
That's right. Someone is asking if hundreds of comments constitute harassment. Would this, maybe it's from one individual, I don't know, but generally speaking.
Harassment's a legal term. I think that's a question you're going to have to, you have to look at them and, 100 thumbs up or smiley faces. I don't know. Depends on what the comments are and what they're doing. And I think that if you have a threat, a real threat, and there's some slides we skipped over because I knew we weren't going to make it to the end on what is actually a threat versus just negative view of something.
Now, would one of those slides have been some sample school committee operational norms regarding social media? Perhaps that's something we should think about as a team of field directors.
I think that would be a good thing to think about. No, the only example of a policy is an actual public comment policy. I did not put in a policy as school committee norms.
The other thing I'd add to that, Abby, is you can always check individual questions on the Attorney General's open meeting law site. You'll find a lot of helpful information there in the trainings they have posted. Would a school committee limit comments to parents? Oh, why would a school committee limit comments to parents only?
I don't think we would limit comments to parents only.
I think a good suggestion is that if you have a sign-up sheet, and Liz, please feel free to correct me if I'm wrong here, name and affiliation to the district. A lot of districts have school choice parents, you have grandparents, you have caregivers, you have a variety of people who for some reason might or might not want to give their address, but they certainly could give their affiliation to the district.
Right, and that's only if you have a policy that limits who can speak during public comment to, as I think I had suggested, it's residents, students in the district, the parents, guardians, or those who the students reside with, and they may not be living in your district. Remember, school choice, Metco, care custody, foster children, McKinney-Vento. There are lots of children who don't reside in our district who may go to our district. Employees of the district can speak. So I think that's certainly a way to, then you might ask what the affiliation, and you might even have a checkbox, are you one of these? But you cannot ask what they're going to say. But if you don't have a policy limiting who can address you during public comment, then, as I said, the group from Arkansas who wants to ban your library books can still come and do that. So you might want to decide who you want to hear from.
I guess this is a follow-up to posting on social media. Can a school committee member post about local Moms of Liberty page?
Can a school committee member post about the moms on her own?
Yes.
On her own personal? Yes, of course. On her own. On the school districts, let's hope we have some limitation on what can be posted and linked, but if not, then she can do that too, because again, it has to be viewpoint neutral. If you have a school district page that is only push out, then no, nobody posts on anything. If you have one that lets people post about anything they want, then yes, they could.
So yes, Amy, it's okay to express your opinion on your personal Facebook page. You do have the right to freedom of speech, as long as no quorum is created there by comments. You also want to be very cautious as to whether or not a quorum of your members are your followers, because as long as they have the ability to see those posts, you still have the possibility of an open meeting law violation. And remember, you do have to come and sit at the table with those folks over a course of years during your term to get business done. Be thoughtful. Right, Liz?
Sometimes we can avoid a lot of things if people were thoughtful. Yes.
Amen. What if a school committee member lies about school committee issues on a Facebook page?
So usually every school committee has a spokesperson. It's often the chair, but sometimes the chair or the school committee designates someone else. If the public has misinformation out there, I wouldn't necessarily comment on that person's, but you can certainly correct it and you can add it to the agenda if there seems to be some miscommunication about what's going on. And of course, the school committee does have minutes. and those minutes should accurately reflect what the school committee has decided to do about something, and those can be made public and are public, oftentimes on your website, so people can actually go and see them.
If your policy states that public comments have to be about agenda items only, and a speaker starts to talk about something different, what is the reaction?
Same reaction as anything else. If the policy says only on the agenda items, what agenda item are you speaking to, speaker? Oh, I'm not speaking to an agenda item. Then we're going to the next speaker unless you want to speak to one of the agenda items.
If numbers dictate more speakers signed up to speak, can the committee vote to extend the 20-minute policy?
You can vote to extend the policy anytime you want.
Right.
And sometimes we don't even vote to do that. Sometimes the chair has the authority by the committee to extend it. But again, sometimes when you do that, it's hard to then stop. You need to, if you're going to extend it, you need to extend it for a specific period of time. If you just say, well, we're going to waive the time period, you could be there for 4 hours listening to comment.
So here's one that I talk to people about a lot in terms of best practice. So let's throw it to you. A school committee member can answer questions constituents send in your private email, but should they only answer through a work email? Through a district issued.
Oh, so I'm going to say, because you don't want to use your
I think
employer's
that's
email.
what she means,
A
right?
district email.
Mhm.
Yes, I would say that anything that comes to your private email that you're answering as a school committee member, I would forward it to your email, your school email, and then respond, because then it's got a record in the school department, and when somebody's asking for it, it's there, and they aren't going to go through your own Gmail account or whatever account you have to find these public records.
But if the public records are requested, Liz, we can be clear to them that they would have to go through their own personal email and pull those all out and sign some sort of a statement through the
affidavit.
Attorney General's office saying that they provided everything that was in there.
Exactly,
Right.
but it's easier to find because if you put it in the district one, if you forward it to the district, then respond, then when you pull up the district one, you're going to know where it came from, and you'll know exactly what date and time to get it from your own email, as opposed to having to go through and trying to search that, which is really cumbersome.
Please use the district email. You will do yourself a great favor by doing so. Can school committee require attendees on a Zoom to show their name on their square?
If this is a public meeting, no, because we don't require attendees to identify themselves when they come to attend our public meetings either. So no.
We will, Carrie, we'll talk as a team about some model language around citizen speak. Thank you for that.
Let's not call it citizen speak, because we're
Public
not asking for the citizen status of anybody who comes to speak to us. Many people reside in this country legally, and some of them not documented, that come to speak at school committee meetings.
Okay, there was one follow-up, and that's about an individual school committee member posting on their personal page about supporting the vote for a new high school, for example.
Yeah, I think that employees of the district and school committee members and officials, there is a time period when you have to be careful, and this is about when you're asking for a vote of an override, for example, for a new high school or things like that. But you still have the right to have personal view, but you need to be really careful. And I would say that these are the kinds of questions that probably need to go to your legal counsel. We are well beyond hypothetical right now and into the legal advice. So I'm going to say that question you should ask to your legal counsel, because you want to make sure, or you can call the State Ethics Commission, and they will advise you, because you want to make sure you do not get that one wrong.
Okay, we're going over time and we like to respect everybody's time. So Liz, Glenn wants you to either stay on this after everybody goes or give him a call, please.
I will give him a call. Thank you.
And I think there's only one or two people here who didn't get their questions answered. If you would just shoot me an email at llafond@masc.org, we will be sure to get you an answer to your questions. They just keep popping up, Liz. We could be here for a long time, and
I
I'm
know
sure.
1 hour was like, it was really hard to squeeze everything into 1 hour, and I feel bad if I galloped a little bit too quickly, but it was nice to see all of you on a Friday afternoon. Have a great weekend.
Uh,
Um,
Thank
it's,
you, Liz. I
thank you.
always learn something from listening to you, so I appreciate it. And I'm seeing a lot of thank yous pop up here as well.
Great. Have a nice weekend, everyone. Thank you.
Thanks. You'll call Glenn?
I will call Glenn.